Here's the difference that decides whether a family fortune quietly survives its founder or turns into a public headline the year he dies. Not how much money there was, not how smart the heirs were. What happens on one piece of paper right after someone dies. A will is a public announcement. It gets filed in a courtroom, it becomes a public record, and it hands anyone with a grievance, an ex-spouse, an estranged child, a lawyer working on contingency, an open invitation to fight over exactly what you had. A trust is something else entirely. It's a machine, built while you're alive, running long after you're gone, quietly making decisions your family never has to argue about in open court. Some families built that machine generations ago, and it's still running today, still paying out, still protecting, still keeping the whole thing out of the tabloids. Other families never built one at all and lost almost everything to a 15-week courtroom battle instead, argued in public, covered in the newspapers, settled with lawyers' fees alone running past $20 million. Same amount of money, two completely different machines. Tonight, we take one apart, piece by piece, the 6 components that decide whether a fortune quietly outlives everyone who built it or becomes a headline the year its founder dies. We start with the piece almost nobody explains correctly, what a trust actually is and why it isn't just a fancier will. Start with the common belief, because it's wrong, that a trust is simply a will with better lawyers attached to it. It isn't. A will tells a court what to do with property that still belongs to you at the moment you die. A trust does something structurally different. It removes an asset from your name entirely while you're still alive and hands it to a separate legal structure controlled by a trustee for the benefit of whoever you name as beneficiary. The property stops being yours in the legal sense long before you die, which means when you do die, there's nothing sitting in your name for a court to divide up in the first place. Most people confuse the two documents because both of them, on the surface, seem to answer the same question: who gets what when I'm gone? But a will only starts working the moment you stop being alive to enforce anything yourself. A trust starts working the day it's signed, and simply keeps working without needing you to still be there. Think of the difference the way you'd think of the difference between leaving instructions for someone versus building a machine that carries out the instructions on its own, indefinitely, whether or not anyone remembers to read the note. A corporation doesn't dissolve the moment its founder dies. A trust borrows exactly that same idea and applies it to a family fortune instead of a company. The clearest version of this in the historical record belongs to William Randolph Hearst. When Hearst died in 1951, his will didn't simply divide the Hearst Corporation among his 5 sons. It forbade them from running it directly, and instead created 2 trusts to hold 99% of the company's ordinary shares outright. Ownership left the family's hands the moment he died, not gradually, not through a slow negotiation between siblings, but instantly, by design, because the design had already been finished decades before his death. The trustees running that structure were never just family. The board was built with 13 seats, 5 reserved for Hearst descendants, and 8 reserved for executives or former executives of the company itself. The same 13 people also sitting on the corporation's own 20-member board. Control was never allowed to concentrate purely in the hands of people who simply happened to share Hearst's last name. According to reporting on the will itself, it also included a clause allowing the trustees to disinherit any family member who challenged the structure in court, a built-in deterrent against exactly the kind of infighting that ends most family fortunes early. More than 70 years later, that same trust is still making distributions to over 65 descendants, none of whom individually control it, all of whom benefit from it anyway. It's built to keep running until the last of Hearst's 15 grandchildren has died. Not 1 generation, not 2. A structure engineered, on paper, to outlive people who haven't even been born yet when it was written. Notice what that in terrorem clause is actually doing underneath the legal language. It isn't there because Hearst expected his children to be greedy. It's there because he understood something most families never plan for, that the biggest threat to a fortune usually isn't an outside enemy, a bad investment, or a market crash. It's the family itself, disagreeing with each other in public, dragging the whole structure into a courtroom out of grievance rather than genuine necessity. A single sentence, threatening to remove anyone who sues over the structure, was enough to make that specific danger far less likely for 70 years running. That's the whole point of a trust that almost nobody says out loud. It isn't really about avoiding a will. It's about removing the fortune from the fragile, temporary thing every single human life eventually is, and placing it inside something built to keep functioning long after any one person involved has stopped being able to make decisions at all. Once money sits inside a trust instead of a person's name, a second question follows almost immediately. What stops someone else from simply going after it anyway? A creditor, a lawsuit, a bad business deal gone wrong. This is where the second piece of the machine comes in, and its origin story has nothing to do with a billionaire family at all. If you're owed something to a person, and that person is entitled to future income from somewhere, a court can usually order that income redirected to you instead. That's true of wages, it's true of most ordinary financial arrangements. The entire premise of a spendthrift clause is that a trust doesn't have to work that way, that a family, writing the rules of their own trust in advance, can specify that a beneficiary's right to future income simply cannot be sold, assigned, or seized before it's actually paid out. It sounds like a small technical detail. In practice, it's the difference between a fortune a single bad decision can drain immediately and one that a bad decision can only touch a little at a time on a schedule someone else controls. In 1882, the Supreme Judicial Court of Massachusetts decided a case that would end up protecting fortunes it never could have imagined. A man named Adams had been left roughly $75,000 in trust by his late brother, a comfortable sum for the era, but nowhere close to a dynastic fortune. The income was to be paid to Adams for life, with a clause explicitly shielding that future income from his creditors. When the Broadway National Bank tried to seize that future income to cover a debt Adams owed, the court said no. That decision, Broadway National Bank versus Adams, became the founding case for what's now called a spendthrift trust in American law, a trust whose income legally cannot be signed away, sold off, or seized by most creditors before it actually reaches the beneficiary's hands. That same doctrine, born from an ordinary family dispute in 1882, is still being tested in courtrooms today and still holding up. In 2016, Massachusetts's highest court heard Pfannenstiel versus Pfannenstiel, a divorce case where one spouse was a discretionary beneficiary of a family trust with a spendthrift clause and an intentionally open-ended class of beneficiaries. The court ruled that his interest in the trust was too speculative to even count as part of the marital estate to be divided. In plain terms, the same structural protection built in 1882 for a modest family inheritance kept a fortune out of a 21st century divorce settlement entirely. The protection isn't absolute, though, and this matters. Even the strongest spendthrift trust doesn't stop every claim. Child support and the Internal Revenue Service routinely reach past the shield that stops nearly everyone else. It's not an invisibility cloak. It's a wall built with specific gaps left in it on purpose, because the law was never willing to let a trust become a way to dodge every obligation a person owes. That distinction matters more than it sounds like it should, because it's the reason this piece of the machine has survived more than a century of legal scrutiny without being struck down. Courts have never treated the spendthrift clause as a loophole to be closed. They've treated it as a legitimate boundary, protecting a beneficiary from the outside world's claims while still leaving the obligations society considers non-negotiable, supporting a child, paying what's owed to the government, fully intact. It protects against bad luck and bad decisions. It was never built to protect against basic responsibility. What makes this piece so easy to miss is exactly what makes it work. It doesn't announce itself. Nobody sees a headline that says a fortune survived because of a clause written in 1882. They just notice, generations later, that some families keep what they have through divorces, lawsuits, and bad decisions that would have wiped out almost anyone else. The third piece solves a different problem entirely. Not, how do I protect this money, But how do I stop the government from taxing it every single time it passes to the next generation? In 1934, J. Paul Getty and his mother, Sarah Catherine Getty, created a trust in her name, capitalized with just over $3 million in Getty Company securities. It wasn't designed to benefit one generation and then dissolve. It was built to benefit multiple generations of the Getty family from a single, continuous structure, with Getty himself serving as its sole trustee. For 50 years, it worked exactly as designed, growing quietly in the background of one of America's most famous oil fortunes. Then, in 1984, Getty Oil was sold to Texaco, and the trust ballooned, by one estimate to roughly $3 billion in net proceeds. By another account from the time, closer to $4 billion, depending on exactly what was being measured. Suddenly, a trust built to run quietly for generations became the center of a very public fight. The family sued to remove Gordon Getty as sole trustee and divide the structure, alleging he'd abused his authority over a fortune that size. 18 months of litigation later, in 1985, the trust was split into 6 separate shares among the family's 4 branches, 26 heirs in total, some of them children, all suddenly beneficiaries of a fortune worth billions, decided by a courtroom instead of quietly continuing as one machine. Here's the detail almost nobody mentions. The family later secured private rulings from the IRS, allowing every trust that succeeded the original 1934 structure to be legally treated as if it had originated back in 1934, a technical maneuver specifically designed to dodge a tax that didn't even exist yet when the trust was first created. That tax arrived in 1986, when Congress passed the generation skipping transfer tax, closing a loophole that had let wealthy families leave assets directly to grandchildren, skipping an entire generation of taxation in the process. But the same 1986 law granted permanent exemption to any trust that was already irrevocable before September 25, 1985, a grandfathering clause old enough that most people have never heard of it, and still active enough that some trusts written before that date are legally allowed to keep growing, tax-free, generation after generation, to this day. It's worth knowing where families go today to build that kind of structure from scratch. South Dakota is currently the only U.S. state that allows a truly perpetual dynasty trust, with no expiration date built in at all. Nevada, its closest competitor, caps trusts at 365 years, which sounds unlimited to anyone but a trust attorney. The two states actively compete for the business of families who want their fortunes clock to simply never run out, offering exactly the kind of legal infrastructure the Getty family had to improvise for themselves back in 1934, decades before anyone had built a state-level industry around the idea. In the fact that a tax law written in 1986, specifically to stop families from skipping a generation of taxation, ended up creating an exemption that rewards the families who built their structures earliest. The grandfathering clause wasn't a mistake in the legislation. It was a political compromise, a way to close the loophole going forward without unwinding structures that already existed. But the practical effect is a kind of permanent head start. A trust finished in August of 1985 sits in a completely different tax universe than an identical trust finished 1 year later, for no reason other than which side of a single date it happened to fall on. Notice what actually happened with the Getty Trust. The mechanism worked exactly as intended for 50 straight years. It didn't fail because generation-skipping trusts don't work. It became a public battle because the structure concentrated too much unchecked authority in a single person, which, as it turns out, is a completely separate problem, and the next piece of the machine. So far, every piece of this machine has been about keeping money inside a structure. This next piece is about something almost the opposite. What happens the moment that structure lets go and hands full control to one person all at once? Imprisoned, every trust has to answer one design question eventually. Does the trustee keep discretion over the money indefinitely, deciding case by case when and how much to release? Or does the trust simply hand everything over, in full, the moment a beneficiary hits a specific age written into the document decades earlier? A fixed release feels, on paper, like the more generous option. Full control, no permission needed, no one looking over your shoulder. It's also the design with no safety net left underneath it once that date arrives. Barbara Hutton was the granddaughter and principal heir of the Woolworth retail fortune. At 10 years old, she inherited roughly $25 million, held in trust and managed by her father until she turned 21, at which point control passed to her completely, fixed and unrestricted, no ongoing oversight, no discretionary trustee standing between her and the money. By then, the trust had grown to around $40 million. She went on to marry 7 times. In 6 of those 7 divorces, the departing husband walked away with a substantial piece of her fortune. Only Cary Grant, famously, took nothing. By one financial press estimate, adjusting for inflation, the total fortune that passed through her hands across her lifetime would be worth close to $900 million today. She died in 1979, at 66 years old, with $3,000 left to her name. That's what a purely fixed trust looks like when it releases everything at once, to one person with no ongoing structure left standing afterward. Compare that to how Sumner Redstone structured control of National Amusements, the holding company behind Viacom and CVS. Instead of a single trustee with total discretion, Redstone's structure used 7 trustees, operating strictly by majority vote, with no single member able to control the outcome alone. And according to reporting at the time, the design was deliberate almost to the point of being provocative. The 7 seats reportedly included divorce lawyers representing opposite sides of the family's own internal conflicts, intentionally seated across from each other on the same board. When the fight over control did come, in 2016, when Redstone removed 2 allies of executive Philippe Dauman from the trust, and Dauman sued, alleging Redstone was being manipulated by his daughter, Sherry, the multi-trustee structure held. It absorbed the conflict instead of collapsing under it, exactly the way it was designed to. The dispute only fully resolved in 2020, when Sumner Redstone died and control consolidated with Sherry Redstone. But at no point along the way did one person, acting alone, simply take everything, which is precisely what happened decades earlier and in a completely different family the moment Barbara Hutton turned 21. It never produced anything close to the kind of single-point collapse that hit the Getty Trust a generation earlier either. It's worth being precise here. This particular structure is technically a corporate voting trust for controlling company shares, not a classic trust distributing income to individual heirs. But the underlying logic is the same one running through every piece of this machine so far. Spread the discretion. Never let one person, however trusted, become the single point of failure for an entire fortune. Fixed and total, released all at once to one person. That's Barbara Hutton, $900 million reduced to $3,000. Discretionary and distributed across several trustees, none of them able to act alone. That's the structure built to survive exactly the kind of internal war that ended the Getty Trust's 50 years of quiet. Everything so far has been about what happens when a family builds one of these structures. This piece is the proof by absence. What happens when a fortune has almost nothing standing between it and open court? Remember what a will actually is from earlier in this video. A public document filed in a courtroom open to anyone who wants to read it or contest it. That's true whether the estate is worth a few $100,000 or several $100 million. The only thing that changes with the size of the fortune is how much attention and how many lawyers show up to fight over what the document says. J. Seward Johnson was an heir to the Johnson & Johnson fortune. When he died, a large share of his estate was left to pass through an ordinary will rather than a trust structure, and that will was immediately contested by his 6 children against his 3rd wife, Barbara Basha Johnson. The trial that followed, held in the Manhattan Surrogates Court in 1986, ran for 15 weeks and was described at the time by the press covering it as the biggest, costliest, ugliest, and most spectacular will contest the country had seen up to that point. Every allegation, every accusation about influence and motive became part of the public record, read by reporters, printed in newspapers, available to anyone who wanted to know exactly how much the family had and exactly how badly they were fighting over it. The case eventually settled. Barbara Johnson received $300 million. The 6 stepchildren split $42.5 million between them. $20 million went to a Florida oceanographic research foundation, and the legal fees alone, generated by 15 weeks of contested testimony, came to more than $24 million. Money that, in a structure built the way Hearst's or Redstone's was, simply never would have needed to exist at all. To the fortunes covered earlier in this video. $24 million in legal fees is more than the entire trust Sarah and J. Paul Getty started with in 1934, an entire multi-generational structure built from scratch, dwarfed by what one family paid its lawyers to fight over a single will. That's the real cost of leaving the second question unanswered. Not the size of the estate itself, but the price of letting a courtroom, instead of a family, decide what happens to it. A second, quieter example makes the same point from a different angle. The Bingham family, which had controlled Louisville's Courier-Journal and a wider media empire for generations, didn't lose it to a lack of legal structure exactly. They lost it because there was no unified governance mechanism strong enough to survive a real family conflict. In their case, a bitter dispute over excluding the women of the family from the board. Without that kind of structure in place, the disagreement escalated until the entire company was sold off. It's a different failure than Johnson & Johnson's. Governance, not trust versus will, but the underlying lesson lines up exactly. Fortunes rarely disappear because the money itself runs out. They disappear because nothing was built strong enough to hold the family together once real disagreement showed up. Put the two cases side by side, and the pattern is unmistakable. One family had a fortune large enough to attract 6 children and a widow into a 15-week public fight, simply because nothing on paper had already decided the outcome in advance. The other family had an entire media empire built over generations and lost control of it not to a competitor or a market shift, but to an internal disagreement that no structure existed to contain. Neither family ran out of money. Both ran out of architecture. Every piece of the machine covered so far, the trust itself, the spendthrift clause, the generation-skipping structure, the distributed discretion, exists for exactly one reason: to make sure a story like Johnson's never gets the chance to happen in the first place. There's a final piece to this machine, and it isn't a legal clause at all. It's culture, a deliberate decision, generation after generation, to make sure almost none of what you just heard ever gets discussed out loud. Every piece covered so far in this video exists on paper somewhere. A will, a trust document, a court filing, a private ruling from the IRS. Paper can be requested, leaked, or subpoenaed. The only truly reliable protection against that risk isn't legal at all. It's simply never generating the kind of public attention that makes someone go looking for the paper in the first place. That's a much harder thing to engineer than a clause in a document, because it has to be maintained by every single person in the family, in every single interview request, for generations in a row, without a single exception. Mars Incorporated, the company behind M&M's, Snickers, and Pedigree, has remained entirely privately held since its founding in 1911, with no shares ever listed on any public exchange. That's not an accident of history, it's a standing decision, renewed by every generation since, to operate outside the quarterly pressure that comes with public investors and public disclosure. Control runs through a voting trust structure established by Forrest Mars Sr. in the 1970s, still operated today through family trusts that manage dividends, succession, and voting rights, all without ever answering to a single outside shareholder. The culture of discretion around the company goes further than most people would guess. According to reporting on the company, its headquarters building carries no visible logo or signage identifying it from the outside. And inside, the company has long been known for an unusual rule. No one at Mars has a private office. Not executives, not family members, no one. A building with no name on it, containing no room anyone can point to and call the seat of power. That's not an accident of architecture. It's the same underlying instinct as the discretionary, multi-trustee structure behind National Amusements, applied to physical space instead of legal paperwork. Never build a single identifiable point that a headline or a subpoena or an outsider could aim directly at. As the story goes, repeated often enough in business journalism that it's become part of the company's legend, though no primary recording or document has ever surfaced to confirm it directly, Forrest Mars Sr. gave a rare interview to Candy Industry magazine back in 1966, felt badly misquoted afterward, and privately vowed never to speak to the press again. Whether that exact vow was ever spoken aloud or not, the pattern it describes held for decades. An American family controlling one of the largest privately held fortunes on the planet, choosing, deliberately, to be almost impossible to find a quote from. That silence is the final piece of the machine, and maybe the most important one. A trust that nobody discusses can't become a headline. A structure nobody talks about at dinner can't become the subject of a contested will covered by reporters for 15 weeks. Every family in tonight's video that kept its fortune intact also, without exception, kept the mechanics of how they did it almost entirely out of public view. The families that lost everything did so in open court, in newspapers, in public record. The ones that didn't, mostly, you've simply never heard of at all. That's really the first place. It isn't that trusts, spendthrift clauses, and generation-skipping structures are rare among families with serious, lasting fortunes. It's that the families who use them correctly have spent 100 years making sure you'd never have a reason to go looking. The visibility you do see, the contested wills, the courtroom battles, the 15 weeks of testimony, is a survivorship bias running in reverse. You mostly hear about the fortunes that failed to stay quiet, because failing to stay quiet was usually the first sign something else had already gone wrong. Step back from all 6 pieces for a moment, because none of tonight's lesson requires a fortune the size of Hearst's or Getty's to actually apply to you. The mechanism is identical at any size of wealth, however modest. Ask yourself honestly, if something happened to you next year, does everything you've built depend entirely on a will, a public document filed in a courtroom, open to anyone who wants to contest it? Or is there already something in place that would keep functioning whether or not you personally were still the one holding it together? The 6 families in tonight's video started out thinking of themselves as the subject of a lesson about legal architecture. They were running a newspaper company, an oil business, a chain of 5 and dime stores, a media conglomerate, a pharmaceutical fortune, a candy company. The structure came second, built, or in one case, never built at all, around a business that already existed. That's worth remembering, because it means this was never really about being the kind of family that plans for 100 years in advance from day one. It was about the specific moment, whenever it came, that each family finally sat down and treated the second question as seriously as the first. Of the 6 pieces you just watched, were complicated to understand either, once you see the pattern underneath them. Ownership can be separated from a person's name while they're still alive. Income can be shielded from claims that would otherwise reach it. A structure can be built to skip a generation of erosion instead of accepting it as inevitable. Authority can be spread across several people instead of concentrated in one, so a single bad decision or a single family conflict can't take the whole thing down at once. And the entire structure can be kept quiet enough that it never becomes a story in the first place. Look again at each piece and notice that every one of them is really answering the same underlying question, just from a different direction. What happens to this after I'm no longer the one making decisions about it? A will answers that question by handing the decision to a courtroom, after the fact, in public. Every other structure in tonight's video answers it in advance, quietly, on the family's own terms, years or decades before anyone actually needs the answer. That's the entire distance between a fortune that becomes a 15-week headline and one that simply keeps running, unnoticed, for 70 years. The instinct, once you have something worth protecting, a business, a property, even a modest but real fortune, is to keep total personal control over every part of it yourself, permanently. It feels responsible. It feels like what ownership is supposed to feel like. But total, unstructured, undistributed control is exactly what Barbara Hutton had, right up until $3,000 was all that remained of it. It's exactly what the Johnson family didn't have any protection against, right up until 15 weeks of public testimony decided who got what instead. Real staying power tends to look like the opposite of that instinct. It means giving up a small amount of direct, personal control now, deliberately, on your own terms, in exchange for a structure that doesn't depend on you, or your children, or your children's children, getting every single decision right, forever, without a single mistake. That isn't really a loss of control. It's closer to the actual definition of a legacy, something engineered to survive you on purpose, rather than something that simply happens to survive you by accident, if you're lucky, or doesn't survive you at all, which is by far the more common outcome. None of this is a suggestion about which specific document you should sign, or which state you should file it in. That's a conversation for a professional who knows the specifics of your own situation, not a video about 6 historical families. What tonight actually offers is a way of thinking about what you build, long before you ever need to think about who it goes to. The families who kept their fortunes intact for a century didn't necessarily start out any wealthier than the ones who lost everything. They simply started asking the second question, what happens to this after me? While there was still time to answer it quietly, on their own terms, instead of in a courtroom, under a headline, after the fact. 6 pieces. 6 real fortunes, each one tested by a different kind of pressure nobody could have fully scripted in advance. A will proven strong enough to survive 70 years and 15 grandchildren. A doctrine born from an ordinary inheritance dispute in 1882 that still holds up in divorce court today. A generation-skipping structure that worked quietly for 50 years before a sale to Texaco turned it into a billion-dollar family lawsuit. A fixed inheritance that went from $25 million to $3,000 across one lifetime. A media dynasty's trust deliberately built with opposing divorce lawyers seated on the same board. An heir's fortune torn open in open court for 15 weeks because no structure like that existed at all. And a candy company that spent over a century making sure almost nothing about how it actually works ever reaches a headline. Think back over what you actually just heard. A newspaper fortune, handed not to 5 sons directly, but to a 13-person board mixing family with company executives, still paying out to more than 65 descendants today, 70 years after the man who built it died. A modest, ordinary trust dispute from 1882 that quietly became the legal foundation protecting billion-dollar fortunes from creditors more than a century later. A single trustee's 50 years of quiet success ending in an 18-month legal war the moment one sale turned $3 million into billions almost overnight. A retail heiress who received everything a trust could give her, all at once, with nothing left standing afterward to catch her. And a media tycoon's holding company that built exactly that kind of catch, on purpose, out of 7 trustees who couldn't agree on anything except majority rule. A pharmaceutical fortune that spent more on legal fees fighting over a will than most families will ever see in a lifetime, precisely because no trust existed to prevent the fight from happening in open court in the first place. And a chocolate and candy empire, still completely private after more than 100 years, still run by a family that would rather you never learn their names at all. Notice what none of tonight's 6 stories were actually about. Not one of them hinged on picking the right stock, timing a market perfectly, or discovering some investment nobody else knew about. Building a fortune, it turns out, is the comparatively easy part of this entire story. A single generation, a single business, a single decision made at the right moment can do that much. Keeping it intact across generations you'll never personally meet, making decisions long after you're gone, requires something else entirely. A machine built to keep working without you standing over it. None of the families tonight needed to be exceptional people to build that machine. They needed to be willing, at one specific moment, to trade a piece of their own personal control for a structure that didn't depend on them or their children getting everything right forever. Because good intentions alone, it turns out, have never once been enough to survive 100 years of the future arriving, generation after generation, whether anyone was ready for it or not. If this is the kind of thing that actually interests you, not how to get rich quickly, because that was never the promise of this channel and never will be, but how real fortunes are deliberately engineered to survive the very people who built them, subscribe, because we take apart exactly this kind of machine, one real family at a time, every single week. Tell us in the comments, which of tonight's 6 pieces surprised you the most? The in terrorem clause built into Hearst's will, the grandfathering date buried in a 1986 tax law, or the fact that a candy company has spent over a century making sure you'd never recognize a single name behind it. Next time, we're going somewhere almost nobody thinks to humorous, sports the ultra-rich still choose to play behind closed doors, entirely away from cameras, and why the sport itself was never really the point of playing it at all. Bless you.